Welcome to the National American Indian Court Judges Association's Tribal Legal Advocacy Training webinar on panel justice. The National American Indian Court Judges Association is a national nonprofit membership organization devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. NAICJA provides broad and comprehensive training and technical assistance to support tribal justice system capacity building and partners with national organizations to educate the broader legal community and public about tribal courts and judges, and builds relationships between tribal and state court judges. NAICJA is the tribal justice training and technical assistance provider under the Bureau of Justice Administration's Tribal, Civil, and Criminal Legal Assistance Program, TCLA, offering training and technical assistance to TCLA grantees and sub-grantee legal aid organizations. NAICJA's TCLA program seeks to increase and improve access to legal assistance in Indian country by providing technical and training assistance for the development and enhancement of tribal justice systems. Further, TCLA will assist in strengthening the capacity and the quality of indigent criminal defense services and defense strategies for tribal justice systems. NAICJA is coordinating and implementing a multi-part training series, including webinars, interactive virtual training modules, and podcasts covering the basics of tribal court advocacy. The training series is tailored for entry-level legal services attorney, either just starting out or those looking to bolster their tribal advocacy skills. At the end of this webinar, we will provide information on how to access the rest of the tribal court advocacy training series. In developing the Tribal Legal Advocacy Series, we partnered with the Center of Indigenous Research and Justice, CIRJ, located in Olympia, Washington. Our presenter today is Ron Whitener, the president of CIRJ. CIRJ provides public defense services to tribes in Western Washington and training support to tribal public defenders nationwide. Before founding CIRJ, Ron previously was the founder and director of the Tribal Court Public Defense Clinic at the University of Washington Law School, and he continues to serve as an affiliate professor at UW. In 2011, Ron was named a Champion of Change by President Barack Obama for his work supporting and encouraging public defense in tribal courts. Ron was appointed the Chief Judge for the Chehalis tribes for 4 years and also for the Tulalip tribes for 6 years. Ron retired from the Tulalip bench in 2020 and currently consults with tribes across the U.S. on tribal justice system development through the Whitener Group, a consulting company Ron formed with his brother and niece in 2009. Ron is a member of the Squaxin Island Tribe of Washington State and continues to be active in his tribal community through commercial treaty fishing and serving on tribal committees and commissions. In today's webinar, Panel Justice, we will give an overview of how tribal courts that use panels of judges for administrating justice. Thank you so much for joining us today, Ron.
Thanks for having me. All right, so today is to talk about a little bit of a type of court system that a lot of people who work in court or go to law school you don't normally see, but is actually fairly common in tribal communities, especially communities in Alaska and a few other, and we're seeing more tribal courts using these panel systems for maybe not everything in their tribal court, but for certain things. And so we wanted to talk a little bit about these. If you found yourself in a system that wasn't one single judge sitting to hear the case, but actually used multiple judges at the same time to hear a case at the trial level. So we're not talking about an appellate level. So the panel justice is actually a very old form of justice. I think a lot of tribes in the United States, it wasn't usually a single judge that heard a case, if you even called them a judge, but whoever was the person that sort of made decisions about settling disputes in the community, it usually wasn't a single person doing it. It was usually several people. A lot of places it was the same group that was the tribal council was also the people that settled disputes. And so it's a very old traditional form of justice. And often a lot of the things that you'll find in courts that use those is that it uses a lot of unwritten law, customary law, and traditional law. And it may not be written down exactly as to why they're using panels. But it's becoming more and more common as a mainstream tribal justice model in the United States. Still very rare outside of Alaska, but It is often used in tribal courts, especially hearing sort of using volunteer judges. Often you'll see them using multiple people that aren't a full-time judge, but people that come in and serve as judges when needed, and often deal with very internal matters to the tribe. So domestic relations, for instance, child welfare issues. We tend to see it in those kind of circumstances. And we're seeing sort of the informal and the formal portion of it. Tribal courts, a lot of tribal courts have been developed modeled after the Western model. They were sort of pushed toward that way by the Bureau of Indian Affairs early on, through the CFR courts. And just as tribes developed courts, they just sort of knee-jerk went often toward the Western model of a single judge sitting between two adversaries who are going to fight over the case. And out of that conflict between the two sides, the theory is the truth will arise and the judge will make the decision based on that. And we see that in a lot of tribal courts today following that model. But we're seeing more and more tribal courts often keeping that model for certain things, but then creating more traditional models as well. This panel method is often, it's somewhat similar to what we also call peacemaking, and we're going to have a separate webinar on peacemaking, but it isn't a circle peacemaking. It is actually the judges, multiple judges sitting and hearing from the parties, and it's a much more interactive. It's not where the judge is a silent referee, usually listening to the two sides fight and then making sort of rulings like a referee would do, but they tend to be much more involved in the discussion, asking questions, trying to help everybody reach a consensus. If not possible, then the judges will try to ultimately decide what's going to be the response and the decision coming out of the hearing. We're seeing more and more that it being formalized, though. We're starting to see more and more codes. When they use this, they're putting it into the codes and sort of deciding what goes to the panel justice system versus what goes to a single judge. Some places it's the main justice model. Sometimes every case has multiple judges, and the codes will be written in a way that says that there has to be a minimum of 3 judges, for instance, to hear any cases. Some cases you can have a panel of up to 7, I've seen, which is a little extreme and gets a little unwieldy, I think, but 3 seems to be kind of the classic panel system. And usually one of the 3 will be designated as the presiding judge who facilitates the court hearing, and will kind of roll along everything and make sure everything's done, with the other 2 judges sitting, being able to ask questions. Then the court will issue orders like a single judge model, but allows the judges to agree amongst themselves on to what the response is. And usually that's the reason often why 3 is picked, because there's unless there's 3 different opinions amongst the judges that something goes 3 different ways, if 2 judges can agree, then you'll have a majority, and the panel will be able to issue that as almost like a majority opinion. So why are we seeing panel justice being used? Well, it's almost in some places it's looking, especially in small communities, we see panel justice used a lot. And when I talk to them about it, and like I said, a lot of this is in Alaska, and I've done about 70 court assessments in Alaska for 70 different tribes. And I would say that the vast majority of the tribes in Alaska that I've worked with are either using a panel system or intend to use a panel system if they're building their tribal courts. And these are for very small communities. So it almost seems a little maybe counterintuitive having more judges for such small communities, communities of 100 people or so. But what they say is that it makes more sense because they don't usually say it like this, but basically it kind of spreads the blame across multiple people. It's harder to focus in on one judge and attack the single judge for making a decision. It's harder to do that when you've got, when you've got 3 judges. I went backwards, hold on, sorry. When you've got 3 judges, it's harder to say, that one single judge made a mistake, or this was because one judge didn't like me. But having 3 judges who can talk about it makes it more palatable to the community when the court issues a decision. It also allows court to have sort of complementary temperaments sitting on cases. And so the case, you know, if one judge kind of is biased one way, then just sort of how their natural personality is, having 2 others on there can kind of balance out different temperaments and different personalities. It's also, for a lot of communities, they just find it more comfortable that especially in communities where the tribal council has been relied upon to make decisions, including decisions for settling disputes, which we see in some very traditional tribes, where tribal councils often are doing more to make acting like tribal courts, or actually sitting as the tribal courts. For them that are transitioning away from tribal courts being the decision maker, going to a panel is something that they're also are used to doing, and it makes it an easier transition when the tribe is transitioning away from the tribal council doing that. The other thing it does is it allows some of these panels to pair up. What we've seen in a lot of places is that they will make in their panel a combination of local tribal judges who are not law trained, but partner them with law trained judges as well, to kind of get, you know, a more modern, you know, law school trained attorney to pair with a more traditional community-based judges, to try to bring sort of a balance of both sort of community knowledge with sort of someone who's been trained to deal with the modern issues that the tribal court are starting to hear. And so we're often seeing that as a way for tribal local judges to actually seek training by having multiple judges hear a case and having one of them brought in from the outside who's law trained. That law trained judge can sort of help the other judges with managing what a court hearing does and train them. And so it almost acts like a training tool as well. So if a tribe wants to look at using panel justice for some of the cases that it hears, here's some things to sort of think about, I think. So what is the goal? I mean, is this I think is a really handy model. If there is sort of a desire for your tribal court to be more traditional, I think this panel justice system is an excellent way to do it. It just, I think, is naturally more traditional than the single judge model. And so it's a good way to start. You know, it does, I think it does work to where it's harder for a defendant to say that the reason why, you know, they were convicted or the reason why they're in trouble is just because the judge doesn't like me. It's a lot harder to do that when all 3 judges say that, you know, you need to be held accountable for something. I think also in other like domestic disputes and things, I think at the same time, in a single court system, you do see a lot of focus on the single judge. If one or both sides don't like what the judge ruled, I think it is harder to blame that on sort of a peculiarity of the judge or an opinion of the judge when 3 judges all agree that a court case should go a certain way. One of the other things you want to do is do you want this to be the main justice system model? You know, what I think we see with panels is that for court systems that are dealing with very internal matters, the court system is going to work better as a panel, but that doesn't necessarily mean that the every kind of case is appropriate in front of a panel. I think if you've got a situation to where like the court is hearing a torts case out of a casino, for instance, or where both sides are represented by attorneys, then it may not be the best place to have a panel system, and doing a much more traditional one judge, strong rules of evidence and procedures for a complex litigation. It may not make sense to use a panel, but it may make sense if, for instance, what you're doing is negotiating a parenting plan for a child, and you're trying to do it in more of a round table way. Not, again, peacemaking. This isn't peacemaking. This is 3 judges hearing evidence, asking questions, and then the judges will ultimately decide. So it's not exactly the peacemaking model, but it is sort of between the one judge Western model and the peacemaking model. And it could be also, I think, in a lot of places, what it tends to be is sort of a voluntary diversion. You can ask people if they want to go to it. You don't have to have cases to where people go into the panel system, but you can have, for instance, if you've got divorce cases, you can see if the participants want to go to the panel system where they have more than one judge. If they're uncomfortable sort of having the single judge hear it, that you're really stuck with one opinion and you've got to win that opinion over. Sometimes they're more comfortable if they've got kind of three people. I think they feel more like they're going to get a better shot with three. So sometimes it's a diversion program where people can opt out of the mainstream single judge system and have their case go to the panel judges. So you could do that as well as to make it entirely optional for people, but having the main Western model still available to them. I think in building it, and these are sort of the things that we recommend anytime you're doing any justice issue is if you're going to start, usually these panels are often elders. We tend to see often that elders are the ones that the tribes use. And so I think it's important to start by talking with your elders about it. Definitely talking to your tribal council, because they're going to have to sign off on it, and your existing judges. Is this something that they're comfortable with thinking about doing? Is there buy-in? You know, we've seen a lot of situations where tribes have tried to really push a new initiative in the court that's driven by the existing judges or the court staff, but didn't involve the community and didn't involve other parts of the tribe that are court involved, such as departments like child welfare departments or elders agencies, but trying to get all of the stakeholders together to make sure that you've got buy-in if you want to implement this kind of change. You want to discuss what these judges are. Is this a kind of case that you're only going to give to judges that are more traditional, maybe not law-trained judges, lay judges? Do you want them all to be law trained? Because you can have a panel with that's all law trained judges, or do you want to mix? You know, is it something to where maybe you want to develop sort of judges from the community who are lay judges, but you want to pair them with law trained judges so that there's a little bit of a training from the law trained judges who you're used to courts, and you can use it as a training model. So those are the kind of things that you definitely want to discuss before you go to actually making changes down the road. And then bringing in those stakeholders, because you want to make sure that they are brought in early and have buy-in. Anybody that might be involved in the panel court system, are there people in probation departments? Are there people in cultural departments? A lot of times these panels are dealing with issues where you're working with people who have substance abuse that have committed crimes. So your behavioral health department, mental health department, health clinic, you want to really look to see what other groups and tools are out there that this court would be able to use and make sure that they're involved in the planning. And then funding for more formal steps is you've got to figure out, can you afford it? You know, is there funding for it? You know, what kind of burdens will it increase? You know, 3 judges are certainly harder logistically to wrangle than 1 judge. So how much of a burden of staff and time management is that going to result in against the tribe? You know, actually implementing it. So making sure that you've got everybody in line, have the plan, making sure everybody understands what their task is, and then actually doing the implementation. And then looking at if you need to make code changes or if you can use a diversion agreement. Usually diversion agreements, because they're optional, you don't necessarily have to have them written and spelled out in the code exactly, but you can have a less formal agreement than an actual code provision that allows you to divert out of the main case and into the panel system. So making a decision of whether or not you have to change your code or if you can get away with a diversion agreement and a handbook to run the court. You know, I think one of the things you have to consider in this is sort of health and safety issues of what's kind of the safe cases that this is going to have. You know, this is similar to like the peacemaking model in terms of what kind of cases are appropriate to go to peacemaking and what aren't. So what kind of cases can they hear? We see them often, especially in family law issues, divorce cases, child custody cases, where they're acting as almost like mediators. Certainly you can use them in small claims, although, sometimes these cases are a little overkill to use 3 judges for when you're just dealing with very small issues between parties. Non-DV protective orders, if we're looking at sort of settling disputes between neighbors or something like that, I think they work well. But that's sort of one of the things you have to decide is, do you want them to get involved in some of the more serious cases? Usually the panel courts are, like I said, somewhere between peacemaking and the Western model. So it's not usually 3 judges sitting up on a bench, although it can, but often it is much more of a round table kind of justice system. And then that necessarily does create a higher risk for the judges than for a case where they're behind a bench. One of the reasons why judges have benches that are elevated, often behind the bar, which is an actual blocking between the gallery and the judge, is it's just barriers that people have to get over if they want to get at the judge. So some places don't want to use their panel system necessarily if they want them to all sit around a table. So they limit it to more lower risk kind of cases. But, if you're going to have even a divorce, may really quickly turn bad. So, are you going to have bailiffs available, probation officers, or someone as part of this group that can do it? The more security you have, sort of the more serious kind of cases you can hear. So here's just a couple of examples of panel cases. QT, Kagan Gungan, they use panels as their primary form of justice system. Basically, any case you have at QT, you're going to have a panel. But they have an escape valve. So, because again, sometimes 3 judges are difficult to wrangle. They're allowed to proceed with 1, but the code makes a priority that if at all possible, that they have up to 3 judges to be able to hear the case. They have decisions by consensus if possible. They really encourage under their code for the judges to reach consensus. If they can't reach consensus, then majority. And then if they get in a situation to where the judges can't agree at all, at that point it goes back to single judge, where whoever is the presiding judge will make the decision if all else fails. And then the judges can bring in other people, elders, council members, or other consultants under their code. And so we see this to where these panels can also pull in these other peoples, and it starts to begin looking more like a peacemaking circle. Native Village of Eyak, 10 judges are appointed. There is their judges pool. So they have a large pool of judges who get training and hear these cases. They require 3 judges for a quorum to decide to hear a case. So they have both a 2-tiered system to where you have to petition to actually have the court hear your case. And then if they believe they have jurisdiction and it falls under their subject matter jurisdiction of their codes, they'll accept it. And then usually at least 3 judges have to sit on a case for them to go forward. And then the 3 judges can then refer to a larger peacemaking circle if they think it's appropriate, and they can reach a consensus agreement through the circle, or to determine appropriate sanctions for certain civil violations. They can go out of the panel and refer things over to the larger circle. Port Graham, again, you can see these are Alaska. This is very common in Alaska. Port Graham is very traditional. They have still their council sits as the judges as well. And that's just the way that it's been. When we interviewed people in the community, that community, which is, I wouldn't say completely isolated, but it takes a plane or a boat ride to get there. You can't drive to Port Graham. They're very used to having their council serve as decision makers for disputes. And there's a hierarchy of the first chief, second chief, with each having sort of roles of trying to resolve the decision informally by having a mediation with the second chief. And then if that's not able to do, the first chief tries to sort of strong arm to get everybody to agree. But if they can't get agreement, then it will go to the council, and the council will sit as the tribal court. And so there can be as many judges as there are council members. But then they also have a more traditional court of elders, so that if the council decides, they can refer it over to this court of elders who applies unwritten custom and tradition to the proceedings to make a decision. And so we see a very traditional model at Port Graham. Kenaitze has a very interesting group. Again, it uses panels. Kenaitze is located within the city of Kenai. So it's a much more urban tribe for Alaska than the vast majority of tribes, which are very rural. They require at least 2 judges to sit on a case, with one being an elder. They have a very strong healing to wellness court that they use. That's actually coming out of Kenai. So the city of Kenai is prosecuting people. They then get diverted to the Kenaitze court, where they go and sit with the tribal court and the state court judge sitting together as the panel, or the state judge and the tribal judge, or more than one tribal judge sitting as a panel to hear these cases. And then they can also refer things similar to the example of QT. They can, and EAC, they can send the case to the peacemaking circle if the judges decide that the case is appropriate for more of a larger group consensus building. And so Kenaitze has the panel and then the circle as well. And this interesting thing about Kenaitze is, again, it started with just tribal members. So they started with members that the Kenaitze had jurisdiction over, along with the state court coming out of the state court. But what they started doing is, it was working so well for the tribal members that now, if the tribe has the capacity to do it and the participant is willing, the Kenai City Court is now sending over non-natives. So non-Indians are going into the Kenaitze Healing to Wellness Court and letting that court sort of decide their, keep track of them and apply sanctions and things to them as well. So it's a fascinating court panel that the city actually found for some people to work better than the traditional Western model, even if they're non-native. So that's our overview of panel justice. Are there any questions?
Thank you, Ron. I have a couple questions. Would you say it's common to have a mix of law-trained judges with a more traditional judge on the panels that you've seen in Alaska?
No, I would say it's more common to have all lay judges. Really, when we see these panel courts, we tend to find them in places where there aren't attorneys available. It's a very rural court, and the option to have a law trained isn't. So when we do hear the panels and we've talked to the places that are bringing in law trained, usually that law trained judge is appearing virtually. So either over the phone or over video conference if they have enough broadband to support it. But there are a few places where there's a mix. They'll have two community members, and then there's a law trained person in the community. There may be a tribal member or a member of another tribe that's law trained that could also sit as a judge, that can actually sit in person. So it varies, but I would say the model that we see most often is they're all lay judges.
Thank you. Yeah, that's a great idea for some of these rural tribes that don't have a lot of law-trained people accessing them. Another question I had was, do the panels ever provide cultural type sanctions, or I don't want to say sanctions necessarily, but do they provide cultural activities to people who come before them?
Yeah, they do almost always. So a part of reason why the tribes that are using panels is to bring more tradition into their court. And so one of the things that they like is to explore requiring people to go and attend cultural events or to learn cultural activities. And they'll often incorporate, almost always incorporate it. Other places would call it community service. They look at it the same way, but they want that service to not just be going and working at a food bank or something like that. They want them to actually do things that are relevant to their culture. So we often see, for instance, going and hunting for elders is a very common one. Gathering for elders is a common one. Cutting firewood for an elder is common. something that benefits the tribe, like community services does in other jurisdictions, but something that has a cultural component to it. Or they'll give them credit for even, attending cultural events, assisting with things like, if there's an opportunity for them to assist with cooking for a funeral, or setting up before a tribal gathering, and helping with the tribal gathering, or helping clean up after, attending and helping clean up after cultural events, or things like having people go sweat and attend even cultural ceremonial things if the person's comfortable with doing those cultural or religious activities. So it's almost always part of it.
Thank you. And you probably answered a portion of this next question, which was NAICJA has an upcoming project on holistic defense, which is where public defenders work with interdisciplinary teams to address the immediate needs of the defendant. So they could work with mental health or substance abuse counselors in addition to their criminal case. Do you think that these types of panel justice models would be helpful in providing or establishing a holistic defense program?
I don't know. Most of the places where there's panel, the types of cases that they're hearing often aren't involving attorneys, or if they are, the attorneys are, sort of advocating for their clients in more informal setting, but the attorneys are doing it. Some tribes in Alaska, the attorneys aren't allowed to talk. That's another thing that we see very common in Alaska, is that this was challenged in the Alaska State Supreme Court, I believe, where an attorney challenged it as a violation of due process. And the court said that it's not a violation of due process. You can't tell them they can't have an attorney, but the attorney doesn't have to be the one that's talking. You can have the person talk. You can require them. So we see a lot of places where the attorneys are not allowed to be the active voice of their client, that their clients are expected to be the one that talks in these more informal settings. And so I think it's one of those things to where it could be it could be beneficial depending. I think it's going to be very personality driven. I think there's certain knowing, you and I both come out of public defense, and, you and I would be fine at it. But then you and I also know a lot of public defenders who it would make absolute crazy pulling them out of adversarial system and doing it. And we see that there's a lot of criminal defense attorneys who are not comfortable, for instance, participating in a healing to wellness court or even in a state drug court, because it's so different from the adversarial fight over every foot model that you see in an adversarial system. So I think if the person and the system is more holistic, it'll probably be easier than if you're trying to jam it into a very well-established, very adversarial system where everybody's used to fighting with each other. So if you get them to buy into holistic defense, you probably could get them to buy into a panel, more informal system. If they're not, they're probably not going to be comfortable with necessarily the holistic defense model anyway. They just want to, they want that good old adversarial model where you can toe-to-toe it all the way.
Well, thank you so much, Ron. Thank you for joining us in this webinar.
My pleasure.
If you have any questions about this webinar, you can email us at info@naija.org with the subject line as the title of the webinar, Panel Justice. You can access the rest of this tribal legal advocacy series through our website at www.naija.org and through links shared on our social media, Facebook and Instagram. We want to thank you so much for joining us. And again, thank you very much, Ron. We appreciate you.
My pleasure.